My affiliation to this is that I am a lecturer and a researcher at the Swedish Defence University, and I am connected to the Center of International and Operational Law. And what we do there is that we lecture and teach primarily. I do on the military programs of the Defence University, so mainly all the military staff that goes through us. There's all the cadets and also those who train for higher command positions like majors, lieutenant colonels, and so forth. And we teach them in operational law, which could be any kind of legal parts that they can come in contact with during a military operation. So what I will try to do here today is to give a slightly general perspective a little bit on how the military, how we think about the protection of cultural property. And it could be slightly twist around a little bit how we think about it. So I'm going to try to do that. And we'll see how it goes. The outline here today is that, first of all, we're going to look at what is cultural property, the definition of cultural property. We've been talking about it quite a lot, but not really touching on to exactly what is incorporated into the definition. And also the protection of cultural property. And then I will talk about what is military objectives, definition of that, and also ROEs, rules of engagement, and the problematic design of rules of engagement sometimes might occur in. Challenges into this, and my own sort of ideas on how we're going to solve this. So that's the general outline on my talk here. So what is cultural property? Now this is the definition taking from international humanitarian law. It's Article 1 of the 1954 Hague Convention. Now, like it's been previously said here today, this is what we usually have today to focus on. This is not particularly new. The legality of protecting cultural property has been around for quite some time. You can trace it back to the 1600s even. But it was not until the late 1800s where it actually really took a leap forward in something called the Lieber Code, or General Order number 100, which was the American order, where they actually then started looking into the actual cultural property. They didn't define it as such, but you can find snippets from where they have looked into that, and also known as the Brussels Declaration and the Oxford Convention and so forth later on, and 1907 Hague Conventions, where they mention the protection of cultural property. And what happens with the legal part is the law is almost reactive. It means something needs to be happening, and then the law comes in and tries to prevent it ever happening again. And the same thing is here. The 1954 Convention is a reaction to what happened in the Second World War. And all the atrocities, mainly by the Nazis in Germany, but also by other countries that was committed. So what they've done is in 1954 they came together and then sat down and actually have a look on what can we do. Can we actually try to prevent this ever happening again? And what we have here is then try to do a definition of what is cultural property legally wise. And it's quite broad. There's quite a lot of things that goes into it. You have, first of all, it's a property of great importance to cultural heritage of every people, talks about. We also have then, such as monuments of architecture, art or history, religious, secondary, archaeological sites, groups of buildings, which is as a whole are of historical or artistic interest, works of art, manuscripts, books, other objects of artistic, historical, archaeological interests, and so on. So it's quite a lot of stuff that needs to go into that, what we consider to be a cultural property. Further, then, buildings who are main and effectively supposed to preserve or exhibit of movable property defined in subparagraph A, such as museums, large libraries, and so forth. are also protected. And this means that you can actually also move movable cultural property into other storage areas, and that storage areas should also be protected. And I'll come back to the problematic part of that. And then centers containing a large amount of cultural property as defined in subparagraph A are also been known as centers containing monuments. So it's a lot of things here you need to consider when you're talking about what is a cultural property, and this is just a small snippet of what the legal part of international humanitarian law considered to be cultural property. Now, we talk about the protection of cultural property. Is then Article 4 of the 1954 Hague Convention. And we're talking about that is property situated within its own territory, as well as within the territory of the other high contracted parties, by refraining from any use of any properties and its immediate surroundings, or of the appliance used for its protection for the purpose of which are likely to expose it to destruction or damage in the event of an armed conflict, and by referring it to from any act of hostility directly against such property. It's quite a mouthful of that. What they do here is they're basically saying that you should not attack it, you should not be putting anything immediately surrounding and so forth of this cultural property. But, and this is the big but when it comes to military thinking, is that you have a wavering clause. And the wavering clause is basically that the obligations mentioned in paragraph 1 of the present article may be waived only in the case where military necessity imperatively requires such a waiver. Now then comes the question, what is military necessity? And that is basically up to the commander or commanders themselves. Because the principle of necessity means that they can use any means necessary if it's within the law to get the operation done. So basically, if your commander feels it's necessary to do something, from a military advantage point of view, he or she has the opportunity to do so. And we'll also come back to that. You also have respect for cultural property. This is 1999 second protocol, which was again reactive to what was happening, mainly what was happening in the Balkans, where they systematically and intentionally destroyed cultural property. So, because of that, it sometimes could be seen as what we call within the legal terms a non-international armed conflict. The 1954 Hague Convention didn't really apply in some aspects to the Balkan crisis. So the protection of cultural property there, which was only in the case of international armed conflict, did not apply to the Balkan, or some parts of the Balkans anyway. So after that, they decided that this can't have this again. So we need to reaffirm what is actually cultural property again, what is the protection of cultural property, and also by doing so, they said that the second protocol also needs to be applicable in both international and non-international armed conflict. So again, reacting to something that already happened. But what they did is that they continue with this, and they went with the goal of ensuring respect of cultural property, again leading back to Article 4 of the 1954 Convention, but also saying again a waiver on the basis or imperative military necessity, pursuant of Article 4, Paragraph 2 of the Convention, may only be invoked to direct an act of hostility against cultural property when and for as long as the cultural property has, by its function, been made into military objective. Which means that has someone, which we'll come to that as well, but someone basically using that cultural property for either communications, scouting, sniping, any of sort of things, then it will shift from being protective to being a military objective, which you legally can target as a commander. There is no feasible alternative available to obtain a similar military advantage to that offended by directing any act of hostility against that object, which means that if the commander doesn't see, well, I can't do anything else, there's no feasible alternative for me, then he legally can take it out. And also, a waiver on the basis of imperative military necessity, that comes again, the military necessity part, pursuant to Article 4, Paragraph 2 of the Convention, may only be invoked to use cultural property for the purpose which are likely to expose it to destruction or damage when and for as long as no choice is possible. Which means that if you don't see any choice as a commander, you can also use cultural property if it has the military necessity and will give you a military advantage. By doing so, you will turn it into military objective, but it will give you the right to do it by this waiver. It's a bit... So here, as a military commander, instead of thinking, oh, I can't do this, I can't do this, I can't do that, a military commander will either think that, hang on a minute, I can do this, I can do that, I can do that. I can use it. I can shoot at it. It comes with certain restrictions that you need to back up as a commander, saying, like, well, why did you shoot on that church? Or why did you shoot on that? Well, there was a sniper in the minaret. Or they used the church tower as a scouting and reporting in our positions. That will be sufficient enough to actually take it out in the military terms. And also it'll be legal to take it out and destroying it. Continue on. The decision to invoke imperative military necessity shall only be taken by an officer commanding a force of the equivalent of a battalion in size or larger. Those who don't know really are into the exact sizes on things, but a battalion it's pretty big. It's a pretty big, there's hundreds of people. So it's a pretty big size of that. And you're thinking that's fine. If as a commander of a battalion, you will actually have some more of a overview of what's going on, and you will understand the strategical implications of things. But when you're continuing, or a force smaller in size where circumstances do not permit otherwise. Now what we have here in most Western armies is that you have an overall commanding structure, and they delegate down their orders on what they want to have been done, and you follow the orders. But when you are out there, you might need to take quick and tactical decision as an officer saying for a smaller group, and you are then allowed to do so. Which means that you also, as a younger officer or a group sergeant or something, also can take these decisions if needed. Now, I get back to why that might be problematic as well. But keep that in mind. In any case, an attack based on a decision taken in accordance with paragraph A, an effective advantage warning shall be given whenever circumstances permit. Now this means that if it is, say that you have a house, and in that house you have a certain amount of people, and you have also, you got intel that you will have they store weapons in there. And you feel like, well, this is then turned into military objective, I need to take it out because it give me a military advantage, it's military necessity by taking this out because it might have anti-aircraft guns in there, or whatever. If you can then, you should give an effective warning. You should warn those people that I will attack this house. The problem with that is that you might lose any advantage you might have to take out the actual people, maybe if you want that, or the weapons, because you might give them enough time to move everything. So that's why this is whenever circumstances permit. So it doesn't mean you have to warn them. The Israelis have really effective this kind of procedure when they do their operations. What they do is that they do something called knocking on the roof. So if they have a house that they want to take out, there might be people in the house, might be children in the house, and they say, we don't want to bomb that, but we don't really want the people, we want the guns, we want to destroy whatever is in the house. So what they do is that they send out a little flash grenade that go bang on the roof. And that has been known to, that's a pre-warning. So that means that within 5 minutes, the Israelis would bomb the house. So everyone would actually then know in the house, because they use it so commonly, that shit, we need to get out. And they get out. And then they bomb the house. And then the Israelis said, well, we followed. We give their effective warning. And thereby they say that we follow international law, we give a warning, we're being the nice people. But they don't need to do it. If they feel like they lose any advantage, if they're after a person instead, and they're afraid that the person then will run off, they don't need to do it. So what I'm trying to say here is that when it comes to this, what the military is looking into is what can we do? What are our options? What are our possibilities? Instead of, no, you can't do this, you can't do that. Instead of looking into, well, I can do this, I can do that, I don't need to do this, and so forth. Continuing on, you are supposed to do everything feasible to verify that the object to be attacked are not cultural property protected under Article 4 of the Convention. Which means that you need to find out. You need to know, as a commander, in a way, what is a cultural property? What is the definition of cultural property? So all that definition we looked at earlier, you as a commander, you need to have an understanding what is then defined as a cultural property. So you're not attacking it. And you as a commander might know that. And you might have gone through this, and you might have had some education on it. But the sergeant, further down and further out, and he also can take such decisions. Does he or she know? Also need to take all feasible precautions in the choice of means and methods of attack with a view to avoid and in every event to minimizing incidental damage to cultural property protected under Article 4. So here you also need to choose what weaponry you use. It's okay to just, if I need to take it out, what kind of weapons do I use? What What do I have to my disposal? Is that a sniper can't take it out with another sniper. Whereas the only thing I have is to actually put a mortar or a rocket grenade into that tower to take it out. So you need to also measuring what kind of methods do I need to take. Refraining from deciding to launch an attack in which it may be expected to cause incidental damage to cultural property protected under Article 4 of the Convention, which would be excessive in relation to the connected and direct military advantage anticipated. So here you need to you need to evaluate what does it mean to take this out? What value does this have if I take this out? And maybe not the value of the actual cultural property per se. It's the value of the actual attack against my military advantage that you look at. So does this give you more of a military advantage to take this out? Then yes, maybe I can take it out. But the main thing here, and the really good thing here, not the really good thing, but the main thing here is the little word anticipated. Because everything is based on how much would you know at the time when you decide to do the attack. So depending on the information you have is what you based your order on. So if you anticipate that this will give you a massive military advantage doing so, based on the information that you have at the time, you may take that decision. That is what you've been judged on, even though if it might turn out later on that it did not give you this much military advantage that you thought at the end. It might be considered to be a war crime by doing so. But if you can back up with them, this information I had at that time, I anticipated that this would be the outcome. That is what you're going to judge you on. You also need to cancel and suspend an attack if it becomes apparent that an object of cultural property protected under Article 4 of the Convention, so say that you have, and this happened in the Balkans, with the American pilots actually aborted missions when they thought when they thought that this property might be cultural property, or it might cause more civilian life than anticipated. They actually waived off the attacks. And that the attack may be expected to cause incidental damage to cultural property protected under Article 4 of the Convention, which would be excessive in the relation to the connection and direct military advantage anticipated. So if you don't figure out that, no, this will not do this, it will not give me the military advantage after all, then you need to cancel the attack. Now you might say that the 1954 convention has actually been signed and ratified by, I don't have the specific number, but a lot of countries have done so. What they have not done is the 1999 second protocol to the convention, which means if you haven't signed it, ratified it, or access to it, then it doesn't apply to you as a country. Sweden only did this last year. Denmark did it this year. It's been effective since 2004. I mean, that says a little bit of the will of doing so. But what you have then to back up a protection of cultural property is some parts of it is being considered to be customary law, which means that you didn't have to. Majority of the international community have signed up to it and been following it. Then it could be considered to be a part of customary law which means that it applies to everyone. And this is taken from the International Red Cross, who have compiled a list of customary laws, which they have. And rule number 40 is respect of cultural property, where it says that all seizure of or destruction or willful damage done to institutions dedicated to religion, charity, education, and the arts and science, historic monuments, and work of art and science is prohibited. The problem with this one, well, not a problem, isn't it, is that, especially from a Swedish point of view, is that include education. And why is education a problem for Sweden, a Swedish military per se? It's had to do with the old standardization of that if someone invades Sweden, all the different bases and all the different parts are going to move out. So all the command stations, all the command structure is going to move out from the centralization. And so it'll be harder to attack. And where would they put these installations? Where is a really good place to put things around the country? In schools. So it's a standard order, more or less, that these should go in to schools, gym halls, or classrooms, and things like that. Which, by doing so, they're turning into military objective. And this no one really thought about. Until quite recently, we go like, oh, hang on a bit. We can't really have this. What do we do then? Or do we take that, saying that, well, according to military necessity, we can do it. We can actually go into a school and take it and use it as a command center. And take the hit. Saying that, yeah, well, we do that, it's fine. We know we can turn it into a military objective. We take that and then forth. Or do we pitch a tent out in the forest somewhere nearby? Or what do we do? I mean, it's not really been decided exactly what to do yet. And most of the times, it might be up to the commander on site to decide if they need to do this or if they can do this. And then also any form of theft, pillages, and so on, then of course vandalism directed against property of great importance, the cultural heritage of every people is prohibited. Now, what actually makes it into military objective then? What is the criteria of a military objective? Because we talked about you turning something into military objective and then it becomes the legitimate target to attack. Well, military objective is the parties of the conflict must at all times distinguish between civilian and objects and military objects. Attacks may only be directed against military objectives. Attacks must not be directed against civilian objectives. Now that is something called the distinction. The principle of distinction. And it's one of the fundamental principles of laws of armed conflict. So what is then a military object? What separates the civilian objectives from a military objective? And if the military objective are limited to those objects that which by their nature, location, purpose or use make an effective contribution. Now that effective contribution means that it needs to be effective for your adversary, for the enemy, and be negative for you. Because that's the first criteria. The second criteria is, and those total and partial destruction, capture or neutralizing in the circumstances ruling at the time offers a defined military advantage. So there's two parts here. A, it needs to be an effective contribution. It needs to affect you negatively. And B, at the circumstances ruling at the time, what you know at that moment you take the decision, it will make a military advantage for you. And the things with this is that it's fine if you can sit and you can do a targeting list before, or in a command center you have time to actually go through things. But if you are further out the line, you might need to take a split decision. And then you need to remember all this as well. The other big thing that you need to also think about and take into counter with when you order something like this is the proportionality. And the proportionality basically is saying launch an attack which may accepted to cause increased loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to connecting a direct military advantage anticipated is prohibited. You think that makes sense. That makes sense. As a military lawyer and as a commander, you will point out to one specific word of this, and it's again anticipated. Because that will give you the option of actually doing it because you anticipate that will give you the advantage. There are holes in this, and there are holes but for the purpose of that military would be able to do what they're supposed to do in a way. That's how they see it. To be able to do an operation, to be able to fight back the enemy. And to take that decisions when they need to take those decisions and have the backing of the law. And when it comes to more today as well, in today's conflicts, you have joint operations, you have NATO, you have the UN commanding of operations. To make the decision-making process go quicker, you have something called the ROEs, Rules of Engagement. And those are internal rules or directives among the military force on how to use the military force. In which circumstances, when, where, or how. What can we use, what weapons can we use, and so forth. What authorizations do we have to use? Who can authorize the use of this kind of weapons or this kind of methods and so forth. And it's basically made up of looks like a matrix where you have numbers and you have what is entitled and a little tick of saying, well, the commander needs to take the decision on this, or the single person can take the decision of that. Basically, lethal force is permitted during X, Y, and Z circumstances and so forth. Some nations, the ROE is a status of guidance to military forces. It's like a guiding principle. And in some nations, it's more like it's lawful commands. If you have an ROE catalog, that will give you, this is lawful command, this is my command, this is what I need to do, this is what I can do. The problem here is that these are rules. They're not law. They're not to be considered as law. They're considered to be rules based on the law. And each country has their own laws. And each country has their own ROEs when it comes to joint operations. And to simulate this a little bit, how it could work to actually comprise an ROE. You have human rights law. And in certain aspects of the human rights law, you see that the line goes down when it comes to crisis and armed conflict, is that for combatants who legally take part in, say, an armed conflict, their human rights are being diminished. Not completely gone, but they can be legally targeted and killed just because they are being part of the armed forces. That's in comparison to maybe being a murderer or something like that. And then you have international humanitarian law that comes into effect. You have troop contribution nation law, the ones who are actually contributing the troops. You then maybe have host nation law they need to take into consideration. You also have maybe a mandate from the UN to consider what can the UN do, or what does the UN want you to do at this part. And within that, let's say, you also have the ROE. What is the ROE telling you can do? And for a specific country, you might have a generic ROE, so NATO have generic ROE, or UN might have generic ROE, but you might not be able to follow that because it goes against maybe your country's law. So in the middle there is what you can do. A little bit. And that is your order kind of thing, what you need to do as a group of, say, for Sweden going abroad and saying like all of this, well, this is your little piece. Now the challenges with all this is that countries have different laws. They have acceded to different treaties. So you have state parties, might be customary law, you have national law to consider in all this. You also knowledge of definition of cultural property and military objectives. So you need to know what is a cultural property, what is when it becomes a military objective, so forth. You have the knowledge of location of cultural property in advance of the conflict, maybe. Special or enhanced protected property, which countries, if you are in international conflict, should send out to you. Saying these are our special, really important cultural property. This is where they're located. Here you go. You can put them on your strike list. Also considering all alternative attack possibilities. What can I do? Can I attack it differently? What kind of possibilities do I have? What do I have in my arsenal to actually, if I do need to do an attack? When we talk about what can I actually use to minimize any damage? And bearing in mind here that the media might even play a bigger role on negatively doing this than the legal part would do. Negatively pointed towards us. And then also, never use maybe cultural property as a military objective or avoid any military use of cultural property or its vicinities. So when you are traveling with your convoy, for instance, that we talked on earlier, is the alternative route to take instead of driving through this site. Must disclose cultural property of particular importance in advance as a country. You need to do that. Take sensible measures in advance to safeguard movable cultural property. It's also within the 1954 Hague Convention saying that if you are thinking that you might be attacked, you should, in peacetime, even take preparations of safeguarding your movable cultural property. And do all in their power to prevent the conflict to affecting immovable cultural property. So with all this in mind, these are challenges that you need as a commander and as a soldier, you need to think about. Even before. And when I was roaming through this, I found this just yesterday. Robin here is put on this blog. He's a German soldier, probably not from the German army, but he's a German citizen who's fighting ISIS. And basically saying, like, when you make selfies on a quiet day, sniping and observing from the minaret, yep, it might be offensive, but to Muslims, but be honest, I don't give a shit. ISIS was shooting from minarets, so do I. Now, what is the kind of solution to this? Because obviously Robin didn't know. My thing is to be the training. You need to train soldiers more into this. There's far little training into the soldiers or special commanders, but also soldiers, into what this means when it comes to cultural protection. And legal parts of it is far too little. And you need to put it as, I think, instead of saying, well, you need to know this, and you need to know that, because you can't attack this, you can't attack that. Instead of twisting around and saying, well, knowing all this, and knowing how to attack this, and maybe avoid this, and what is the cultural property, and what is the cultural heritage of where you're going, will give you more of a mission success. Because military thinking of is the mission success. They want to succeed. And build better military tools, standard operational guidelines on how to do this. Put them more into operational planning and targeting listing, and also the willingness for the International Criminal Court to take this up, to address this more. Because so far, there's only been one conviction, and that guy actually pleaded guilty from the beginning. So they need to actually address this more for it to become more of a solution on the protection of a more international scale as well. Thank you.